Our guest today is Eliza Ganuni, who is a certified specialist in bankruptcy law by the State Bar of California. With a track record of achieving results for her clients, Eliza's expertise spans various bankruptcy chapters and districts in the state of California. Her passion for bankruptcy law and her dedication to her clients make her a trusted advocate in navigating the complexities of bankruptcy proceedings. Eliza is also a good friend of mine and who I refer my bankruptcy cases to. So, welcome to Legally Uncensored. So happy to have you.
Thank you, Demetria. I'm so happy to be here.
So, before we get started, can you explain to people that don't really know or may be considering it, what is a bankruptcy?
So, a bankruptcy can be so many different things. A lot of different chapters that apply to people and companies. A lot of people have heard of Chapter 11 because that tends to apply to, big companies. When you hear in the news, oh, you know, specific company filed bankruptcy, usually it's a Chapter 11, and that's a reorganization. It can apply to people as well if they have a lot of debt. There's also Chapter 13, which we also call a mini Chapter 11. It's also a plan of reorganization. That tends to apply to people who are behind on their mortgage, they want to catch up, save their house, or they make too much money to file what's called a Chapter 7 bankruptcy. Chapter 7 bankruptcy is the bankruptcy that tends to apply more often to individuals. And that's basically what we call a fresh start, where you might have a lot of credit card debt, you might have a lot of even tax debt. Sometimes you can get rid of student loans in a Chapter 7 bankruptcy if you can show that you have a lot of hardship, if you're disabled, etc.
Okay, what are the financial limitations on a Chapter 7 before someone has to go to a Chapter 11?
Well, the difference between like a Chapter 7, let's say, and a Chapter 13 or Chapter 11 is income, but also assets.
Mm-hmm.
So you don't want to file a Chapter 7 if your assets exceed what you can protect. And what you can protect is determined by state law. So even though bankruptcy is federal, depending on where you live, that'll determine what kind of assets you can protect, even down to the county you live in.
Oh,
So, for
wow.
example, yeah, if you own a house,
Mm-hmm.
the amount of equity you can protect in that house depends on the county you live in. So, the equity in a LA County is different from the equity you can protect in Riverside County, Ventura County. Yeah,
Mm-hmm.
it depends. It's county specific.
What is it in LA County? I asked because it's so high right now. So, what is it in California? I
Right,
mean, excuse
right
me, in
now,
LA County.
right now in LA County, it's about like 678,000,
Wow.
and that actually went up a lot over the past few years. It was only like a maximum of 175,000. And it went up considerably. So that was
Mm-hmm.
definitely a game changer for people who had a lot of debt issues because it allowed them to protect a lot more equity in their property and not have to file, for example, a Chapter 13.
Got it. So, I invited you here today because this comes up a lot. Like, if one party has filed for bankruptcy without
Mm-hmm.
including the other party,
Mm-hmm.
or when someone files during the divorce proceeding, which is horrific. So let's talk about that. What happens when somebody files without their spouse? Is that spouse on the hook for the debt that is excluded?
I'll answer in usual lawyer fashion. It depends.
Right.
So every case is so, it's just such a case by case basis.
Right.
Sometimes if two people are, let's say, separated, they can still file bankruptcy together and it might be beneficial for both of them. Sometimes if the separation is not amicable, one person might file to get an edge over the other person in the family law proceedings. um, it really depends. It's so fact specific.
So how does that impact? I know what happens in because bankruptcy is federal. Once somebody files, once the process begins, that puts a stay on anything that the family law court can do in terms of property division and that sort of thing. So, how would that impact property from your perspective of a married couple if one party gets a bankruptcy and the other party doesn't? How does it impact the party that didn't file for bankruptcy?
Well, I can give you an example of like what happened in one of my cases,
Mm-hmm.
which has been concluded. So, and it's all public record. I had my client was in a very adversarial divorce. She was being pursued by creditors who, she kind of said it was the fault of her other spouse because there was businesses and etc. So she filed a bankruptcy, and there was a property that was under her name, and it was considered community property. So the other spouse lost out on the equity in that property because there was no exemption. So there was a very limited exemption. So the other spouse just lost that property, lost the equity in that property. So, sorry, did that answer your question?
It did, because I want people to understand the seriousness of what happens when either party files for bankruptcy. Because it's a federal proceeding, the family court can't stop it. Now, there might be sanctions involved and some other repercussion on the other side of things, but you can't stop it from happening.
So so let's say you're in the middle of a family law proceeding and one party files a bankruptcy, the other party can file something called a motion for relief to say, hey, we want to go forward with, child support or alimony.
Mm-hmm.
And they can do that. With regards to community property, what's separate property, the bankruptcy court does leave that up to the family law court. But yeah, as far as dividing assets, it would kind of, it's a little tricky, and the bankruptcy court might say, okay, we're going to have to wait to see what's what, like what assets the court can administer. So the bankruptcy court definitely has to give deference to the family law court with regards to what is community property, what is separate property. But filing a bankruptcy doesn't entirely, it'll pause family law proceedings. It won't stop them altogether.
No, but I mean,
Indefinitely.
if a property is already gone to the bankruptcy court or the not the bankruptcy court, the who holds the
The
property?
trustee,
Yes, the trustee. Once it's gone to the trustee, is there any recourse for the party who lost out on the property? Can they come and say, "Wait a minute, that was half of my property"?
So yeah, that's where it gets a little tricky because community property it's not really necessarily 50-50. It's kind of like what the community owns.
Mm-hmm.
Um, so the other party can end up, losing out on their share. Um, if let's say the parties have a division of assets prior to filing bankruptcy, and
Mm-hmm.
so the assets are divided by the family law court, and it's considered a fair, like, for consideration. So each party gets kind of like what they're entitled to under the law. Then that could end up being better for the other spouse. But if it's filed while they're married, the other spouse could end up, you know, losing out on assets.
Yeah, that's what I was going to ask. So, are you able? Does if I want to file for bankruptcy and my spouse says no, I don't want to do it. As a married person, can I still proceed without my spouse?
Yes.
But because I'm proceeding, it's likely that our community property can be impacted.
Not likely. It will be.
Oh. So, is there anything that I can do as a spouse that does not want to file for bankruptcy? Is there anything I can do?
You can try to communicate with the other spouse so that they, they don't file. I mean, it's sometimes people file really to be vindictive,
Right.
sort of like a
Mm-hmm.
scorched earth. I don't care.
Mm-hmm.
You know, if I'm not going to get it, you're not going to get it. So yeah, as far as what you can do, I mean, theoretically, you could then file your own bankruptcy, or you can negotiate with the trustee. There's always room for negotiation.
Okay.
So if a trustee sees an asset that they think they can administer, and the other spouse wants to keep that asset, they can negotiate with the trustee if it's beyond what's available to exempt if that makes sense.
No, it does. It's just really scary that someone can put everything on the line in this way.